Welcome. Good afternoon, and thank you for joining us for today's Luncheon Law, a full court press on the SEC gag rule. I'm going to start this discussion with a question. If you were told that a powerful government agency could charge you with violations of the law, and then the price of settlement with them was that you had to agree to never publicly question their charges against you for life. And in addition, you had to untruthfully say you consented to that gag and agreed to waive all notice and comment to be heard on the terms of your settlement. Would you believe you're living in the United States of America? Yet, for 50 years, SEC has done this with impunity with thousands of people with whom it has settled its cases. Today, we will be talking to two parties willing to take the SEC to court over this, along with 7 other brave Americans, and also with a newspaper publisher who tried to report on both sides of an SEC settlement unsuccessfully, and he wants to vindicate his right of the press to report on both sides. Our first individual challenger is Cassandra Torian, owner of a successful investment firm in Delaware, until SEC charges came crashing down on her life and her business. Torian did everything in her power to negotiate for a settlement with no gag, and she met with a stone wall that permanently forbids her to truthfully speak about the SEC's enforcement case against her. With us today is also Christopher Rausch. He's the owner and publisher of the Cape Gazette in Delaware. He tried to tell Cassandra's side of the story, and we'll talk about that today. And he believes that responsible journalism means reporting both sides of the story free of government imposition of gags on the people with whom they settled their enforcement actions. Our final guest today is Thomas Powell, also a successful businessman until the SEC put him in its crosshairs, seeking huge penalties, and he'll talk more about that. He later settled for a modest price, except that price included a steep price of silence about the agency's claims against him. It came at the cost of permanent reputational damages, and that is the price of all enforcement actions with the SEC. I should also mention that we will talk about some other individuals who have joined in this petition, but Reason magazine has also challenged this rule, and they have been reporting on this topic for a number of years and are very much front and center in the challenge here by the press interests against the SEC gag rule. So I'm going to tell you what the rule is first. There are 2 categories of problems with the rule. One is procedural, the other is substantive. And I'm going to do nothing more than list the problems because we're not here to argue the case, we're here to understand the case. The procedural problems are there's no notice and comment when the rule is passed. The SEC also requires people who sign the settlement agreements to agree to waive all notice and opportunity to be heard by a judge or court of law on the gag. Actually, there's no gag even provided for in the rule. It's a technical point, but important in this area of law. And it's essentially guidance that morphs into a rule. And those of you who understand administrative law will know how pernicious that can be. Substantively, the gag is a prior restraint. It is also a content and viewpoint-based discrimination on what Americans can say. It is an unconstitutional condition that the SEC could never win, even if it won its case against you. It violates due process for vagueness and against public policy, and it also undermines accountability essential to our democratic governance. It violates settlers' rights of petition, as amply shown in the 5-year delay in the SEC ruling on our petition. The SEC, under its own enforcement authority, has no authority whatsoever to impose a gag on anyone. They have no statutory authority to do this. It suppresses truthful speech. And that's proven because there's a provision in the gag that says, well, if you're put under oath and you have to tell the truth, then you're relieved of the gag's prohibitions against criticizing the agency. Well, that shows you right there that they understand that this is going to suppress truthful speech. And finally, Congress itself could not pass such a law. And that we know that because when Congress tried to pass such a law against judges talking about judicial discipline, that was set aside by the first court that ruled on it as violative of the First Amendment, and the government did not even bother to appeal that decision. So I think it's time for me to move to Cassandra and Tom and have them discuss in their own words how the gag impacts you from the time you were charged to the present. You want to start, Cassandra?
Sure. Thanks for having me, and thank you for letting me be a part of this, and thank you both for also being strong fighters as well. I think that's definitely something that takes courage. So I basically, from the moment that I was sued, was told by my lawyers, don't talk about this with anybody, but it's public. It's a public filing. Its RSS feed goes out there to everybody. And so, of course, my phone started to ring from the press, and I wanted to be able to, I was really upset with what had been with the process up until that point. And I desperately wanted people to know what this process was like. I had no idea that we have this thing called the regulatory government. Just FYI, I did a year of law school, so it's not like I'm foreign to legal terminology or anything, and took constitutional law, and I was shocked at what was going on. And basically, I was fortunate enough to be contacted by the Cape Gazette, Chris's paper. We live in the same town, and they called and said, we got a hold of this story and we need to publish about it. And I said, please, nothing's proven, I'm going to fight this. And they said, well, what we can do is give you equal time. And so they came to my office, and thank God that I didn't listen to my lawyers and I let them come to my office and interview me, because I had no idea that was going to basically be the last and only time, potentially in my entire life, that I had a voice in any of what had happened to me. I at least could get out there a bit and express my anger and frustration, and the emotional turmoil the whole thing had taken on me, and not to mention, family turmoil. But beyond that, as things progressed, it was business as usual. It was literally business as usual. I was running my business as usual, and I kept in touch with Peggy since probably 2021, I guess. And so I knew about this gag rule being out there, and I was like, no way they will ever. She's like, you'll see if that's the road you end up going down. And in fact, and I think I can say this, there was a previous time I almost settled. And actually, the terms were great, but I looked at the document they put in front of me, and I knew that it was going to have a gag that I had to agree to. But what I read in the complaint, I felt I couldn't swear in a Bible. And so at the last minute, I said, no, I'm sorry, I can't do this. Well, that angered that just angered. And I think I therefore, paid monetarily for that in the end. But you know what? That's okay. Where I know that I have had issues since even my settlement is I've had to change banks. I have been I've suffered from the new bank cancel culture. I've had to change custodians for my investment accounts. Despite the fact that I say there's a settlement out there, you can read it, this is all done. I can't say any more than that, right? I can't, when you're accused of fraud, right? And you have no speech left to give to explain anything, it's very frustrating. And then the other thing is, I do want to write a book, and I want to be able to go and talk to people in Congress about this process. Again, I'm not even talking about anything factual. I just want people to know. I get phone calls from other people in my industry that are just at the beginning of this happening to them, and they call me after reading the one and only article where I was quoted in anything, and they search the internet and they find me and they say, how did you get through all of this? And you realize they have no idea what's in store for them. They can be in this industry a long time, have hired the best that is out there, and still end up where we are. And it's time.
And Tom, I'm going to turn to you in just a moment, but what Cassandra just described reminds me of a rom-com movie with Jack Nicholson, of all people, and Paul Rudd and Reese Witherspoon. And anyway, the Paul Rudd character is charged by the SEC, and he goes to his lawyer, and his lawyer says, your life will never be the same again. It is altered unconditionally. So. And that's what I heard from Cassandra. Tom, tell us about your case.
Well, that's not the truth. Tom Powell, and I first of all, I appreciate being here because I have been pursuing this on my own and have spent, through the enforcement action, we spent a little more than $6 million over 4 years. We were never named, we were never charged. It wasn't even our name or our company's name on the document. And then a fateful day in October 2020, we got the call that said, hey, we're coming up against statutes and we're going to have to move for a Wells unless you settle. And sign a tolling agreement. Sound familiar?
A topic maybe of another lunch.
Yeah.
Go on.
And we're like, so we've been on the helpful side of this whole thing, and it was a very interesting prospect. And when we did hire our white collar attorneys, which I thought that was an interesting piece to begin with, they said, oh, this is going to be a very long process. And I swear I heard him say in the background, honey, go ahead and start the remodel on the house. And my wife said, maybe we should stop the remodel on our house, type of scenario. So, it was a process. And I go back to, having gone to school in the early 70s and early 80s and civics class, that, the difference, and I did know the difference between civil law and criminal proceedings, and they would keep popping in when we'd say, you can't ask for that. And they'd say, well, we can just call our big brother DOJ, and they'll really make your life much more difficult. Right, scenario. So the whole process was very interesting. When we got to the final agreement in that October of 2020, there was a set of settlements that were actually, I guess, tolerable. And we said, for what we were going to settle and what they had initially had asked for, which was a very, very, very large amount of money, in the hundreds of millions of dollars initial settlement. And what I settled for was $75,000, which is public, which also says, that was less than we were spending a month on attorneys. And I was supposed to be able to continue in business. And it was non-scientur, which meant there was no knowledge And there was not supposed to be a press release. And all of these various things, we'd have to put it on our website for 3 years. And we'd have an ICC, which is internal control, come in and do that. That was all agreed to, and then administration changed, chair changed, and they said, oh, commission's not going to sign off on this. And it changed dramatically to a scenario that all of the penalties still stayed within that, within the, it was non-scienter, but at the end of the day, they said, but we knew, or should have known, which was a new thing. And they did a horrific press release, which has untruths in it. And when our counsel was responded to the newspaper about those untruths, the SEC shut them back down and said, you cannot comment on this.
This is to your lawyer.
This is to our lawyer, right? To say that you cannot do that. So we literally found out that we had to do that. And I had gone back and I have a 35-year career in being in lending, commercial lending and banking, and our private equity was international. And so we have a reasonably good understanding of this. We're a service provider more so than actually being in the securities business. It's only through Dodd-Frank that they actually were able to reach us in the scenario where they could say this was outside their scope and say, oh, we've got activity to get there. And in lending, there's a rule that did get passed by Congress, but it's around bankruptcy law. And borrowers cannot, through contract, give up their right to file bankruptcy, no matter what a bank says. And what I was curious about was if that's through Congress, a congressional law, and bankruptcy was set up by our founders, essentially to say, look, we don't want to have debtors' prisons. Why is it possible that our government is able to put a gag order against me that is clearly a violation of our constitutional rights? And our constitutional rights were not about us being able to argue and have the right to free speech. It was actually the right to be able to initially speak out against our government.
Right.
Precisely.
And so, that's been the frustrating part. Similar, great reputation with my banks and lenders and everything, and those almost all, with the exception of a couple great banks that I love, cut those off immediately. And including things like we had IRA, we had retirement accounts for our employees, and my account had to be closed because I couldn't have my account any longer there. Which was a ridiculous, scenario without explanation and without cause back to us. They just said, nope, you violated some piece within, and you can't even explain a way to it. The personal reputation and such of telling the family. And you mentioned fraud. The first thing our white collar counsel explained to us was there's two definitions of fraud within law. There's the fraud, oops, we made a mistake, and that's fraud. And then there's the fraud that everybody thinks of is I stole from you purposely. And the words are the same, and they're used in the same language within there, and especially in the press releases and such, that it comes across that, there might have been a mistake. We still don't, say that there is a mistake within the documents, but there might have been a mistake in the documents. And because of that, that's fraud. And so that's where the lead went to.
Yeah, you went on to get a doctorate to understand how this could all go so wrong, right?
Yeah, so I first went to Pritzker Law School and did my master's of legal while I was going through this, and then a doctorate law in law and policy at Northeastern University. And for me, my thesis was actually initially going to be on the SEC. My wife said after all these years, she said, maybe once you're done, every day you're still going to wake up pissed off. So why don't you figure out something else that you might be more excited about and then still pursue this as part of the research? So,
sounds like good advice.
Yeah, it was.
One thing a friend once told me is if you go through something horrible, don't relive it.
Yeah.
Don't relive it. So Chris, tell us about how you came to know about Cassandra and also your thoughts about why you're in this case and the things that you hope to vindicate here.
Yeah, so thanks for having me. I appreciate it. And as mentioned, I'm the owner and publisher of a community newspaper called the Cape Gazette in Lewis, Delaware. And I think that distinction of being a community newspaper is important here. As Cassandra mentioned, we live in the same town. The very first editorial, which was written by our then editor and part owner of the paper, was about fairness And so a lot of that had to do with be fair with the people you're dealing with, be fair with the people you're writing about, because you're going to come face to face with them, you're going to come eye to eye with them, and if you're not fair with them, it's going to come back on you. So when we first anonymously received the release from the SEC, we contacted Cassandra to give her an opportunity to tell her side of the story. And I know originally there was some reluctance, and you were getting advice from your attorneys, and like she said, we did eventually run some of her comments prior to the actual settlement with the SEC. But during that conversation and speaking with her, I felt like the only thing that I could offer was that offer of fairness on the back end. I said, look, we have to run this. This is our responsibility to do this. But if you're found innocent, if this is dismissed, I will, with the same full force, report on clearing your name in the Cape Gazette. Little did I know at that time that 98% of these go to settlement with this gag order capped on top, leaving no room for fairness, leaving no room for Cassandra to tell her side of the story. As I was reviewing the materials provided, the one thing jumping out to me was Commissioner Pierce's dissent piece. If the SEC is so comfortable with the facts they've gathered during their investigation, why are they so adamant that those facts never get released or never see the light of day? So they've seemingly, through policy of their own, created themselves a situation where they're operating with very little oversight. And I don't think I need to go into any great detail as to why it's problematic when these government agencies operate with no oversight. So we jumped on board because we see an issue here with fairness. We certainly don't believe this is in the spirit of the First Amendment. And we don't believe this is what the American people expect in open government. So happy to lend a hand here and do anything we can.
And we're very grateful. This requires courage on everyone's part. I mean, you can see Tom and Cassandra navigating about what I can say, what can I say, and it's really diabolical. I also think that one of the things built into the role that is not well understood is these folks were told, you will settle on a no admit, no deny basis, which is a very common way of settling a case, and we have no problem with that. Everybody just says, we settled, and then we go on and tell our story. But the way the rule works is that they actually take away the no admit. If you say, I did not admit to these charges, you are forced to say by the terms of the order, but I also don't deny them, which is compelled speech, and it essentially guts the no admit part. So there's something truly diabolical about that. I would also note that in that gag, it requires you to withdraw any pleading that you had filed in which you denied the claims. You got to send that down the memory hole, which is really something pretty much like the Soviet Union. You're photoshopping the record and taking away any denial that you have paid a lawyer to file on your behalf that is the truthful historical record of the case, and that has to go down the memory hole. I mean, this really is astonishing. Chris, you have also had some issues with FOIA, and I don't want to spend too long on it, but it actually does become part of this whole larger topic. And tell us what happens when you file a FOIA claim.
I mean, this is sort of what piqued our interest in this particular case as well, because I don't believe this is just a matter of SEC gag orders. We struggle. We recently, back in December, just wrote an editorial. 90% of the time when we file a FOIA in Delaware, it's denied. The broad guardrails in the way the FOIA law is written, any lawyer worth his salt can find an item in those guardrails that allow for denial of a FOIA. And most of the time it's somebody within the agency that you're sending the request to that gets to decide whether you get the information or not. So it's become a symbol of government where they say, hey, we're open, you can just FOIA any information you want. But in reality, we're not getting that information. And I know it's a little off topic, so I won't go into detail of some of the stories where we've really found things problematic. But I think this problem is pervasive throughout government.
And it is. We can do another event on that one. Let's see, where are we? I think it's appropriate to mention some of the progress that NCLA has made in this context. We filed our petition that is the subject of the action that we're talking about today in 2018, and the SEC did nothing on it. My colleague, Kara Rawlins, who I hope will ask the first question today because she knows so much about this, renewed that petition last December, and that finally prompted the SEC to rule on the petition. But before that happened, we had taken cases on behalf of Barry Romeril, who is one of the plaintiffs in this case. He's 80 years old. He has been gagged for over 20 years, and he wants to tell his side of the story. And in that case, we were able to join with Floyd Abrams, a prominent First Amendment lawyer, to try to get his case to the Supreme Court, but that was unsuccessful. There are 3 judges on the Southern District of New York who have been extremely critical of the rule that they enforce every day and put into practice every day. 2 judges on the Fifth Circuit Court of Appeal have said it's a plain prior restraint, and that a more effective one is hard to imagine. And Judge Abrams, one of the Southern District of New York judges, issued a resounding opinion as to why this rule violates the First Amendment. We also got a great comment from Justice Gorsuch at the Supreme Court in a different case, but he dropped a footnote about what he called agency extortion in that case, citing Philip Hamburger, who is our founder, and said that because the costs are so great of these proceedings, that the agency can outlast and outspend you. They are able to get in settlement terms and conditions they could never win at trial. And that's one of the most pernicious parts of this rule. If Tom and Cassandra had lasted out and whether they were found guilty or not, or totally exonerated, they could say whatever they wanted about the SEC. It's only if you settle. And yet, because of the costs, 98% of the people are forced into a position of being totally silenced. And there are, Cassandra had mentioned about concern about your ability to petition and why that was concerning you. Why don't you expand on that a little bit more?
My ability to petition.
To go to Congress and talk to them about that. The right of petition.
Yeah, why I want to do that?
Yeah.
Well, part of the reason why I want to do that is I see there's just, it's a bunch of lawyers, right? They're not business people. They've never been on this side before. And I don't think they understand there's serious structural issues with the way that agency operates. And, when really smart people like us, who we're no schlubs, we both even know something about the law, see this and getting phone calls from other people behind me, and I hear the pain in their voice, it makes me say, you know what, I don't have to worry about, kids and college and all this other stuff. It's just me, myself, and I, and my partner, right? And my mom. But other than that, who can really do this and not feel like they're risking everything? And I feel like they need to hear all of the things that were done. This is not just a smooth little process. And I won't say more than that, other than just say that, there's plenty of tactics that can be used, that they do use. One of them being the dragging out, causing financial, decline over time. But that's just one. I think I've even said it publicly, in the papers about just this is a mental game as well. The settling as a business person, for me, that boiled down to just wanting to get on to my life. And I said to my lawyers, so I can pay this money, agree to have no license anymore because I didn't want it. I can do all these things, hand them a bunch of money, and for that, I get the pleasure of never having my voice again. Wow.
Steep price.
Steep
Ariel.
price, but you know what? That's why I'm sitting here. And that's why I agreed to, I was very lucky because I had a very strong business. I was lucky to be able to thread the needle and come out relatively, whole and help with this. I was ready to get on with what I saw the bigger fight. I could have gone to court. I have no idea if I would have won or lost. I know we were well prepared, but the bigger issue to me, that would have just helped me. And I realized I needed to help everybody. And that's part of why I feel very strongly about writing the book, going to Congress, telling anybody I can with any position to change this, to let them know.
Well, and the one thing we haven't mentioned yet, but it's a very powerful argument, and we keep making it in court. There are only 2 agencies in the United States that think they can do this, the SEC and then the CFTC, which is the commodities version of the SEC. And they passed this rule with no notice or comment. It just showed up in the Federal Register one day as effective immediately. So it's illegitimate at its birth. It is completely illegitimate. Any lawyer can tell you that a rule that imposes and binds a gag on people has to go through notice and comment. So illegitimate at birth, only adopted by 2 agencies who are under the delusion that they have this power to do it in the first place. And every other agency, state or federal, in the United States seems to be able to robustly regulate Americans without gagging them. Mm-hmm. It is such an odd thing for people to be able to do this for 50 years. It's astonishing, and it must stop.
It just tells me there's fear.
Well, it does.
And I didn't think that the United States was, up until the last probably 7 or 8 years, I didn't think that this was a country run by fear, but now I see how much of it was an illusion to me growing up.
Can I comment on that? Because part of the settlement agreement also comes with a statement at the end that says, there was no coercement or extortion to extract this scenario. And I will say that, again, even subject to my gag order, there was nothing but extortion and coercion throughout this, because there was monetary coercion, which was, I'd said, look, I'll take this to court. And they said, great, well, we'll go through administrative law and then judges, and then you'll have to go to, move this to a federal court. And then if you're going to take it all the way to the Supreme Court, plan 6 years and $10 million. And I'm like, all right. And my family's sitting there going like, we don't want 6 more years. The money was one thing, the time was another thing, to scenario the stress that was in there. The second part was, and if we didn't sign it, that they would extract all of that pain, plus they said, we think that, we could send in the DOJ, and boy, I tell you, that's a much more painful scenario that you go through. Like, we didn't do anything. You guys know we didn't do it. So it didn't matter how that went through. And then to sign a document that not only gives up your voice, but then specifically says you were signing this saying you didn't coerce it, sounds like when we used to get forced confessions. Right. And
right.
So as you go through as you go through law school and you're learning about all the various cases that have happened in that scenario, it doesn't get brought to light because this is civil. Right. It's not criminal. Right. So we don't have all of those same pieces that are within there. Yeah,
that is just one of the most pernicious things. You have to say you agree to be gagged. Mm-hmm. Yep. You have to say you agree to give up your right to be heard in court. And there was no pressure, there was no extortion here. And to your point, Tom, I would just simply say, see Justice Gorsuch, footnote 4 in the Cochrane opinion as to whether this amounts to extortion. So, it really is shocking. And I think we have to be unafraid to say that the admissions that are extracted from people who are in this terrible position of being settled, it is just shocking that they are forced to say these untruthful things. And it is is utterly un-American. And so I'm glad that today you can have that voice and talk about the process problems and what is, haunting you. What are you gathering from all of this?
The one thing that keeps jumping out to me as I've read through everything and I'm listening to them speak today is, just trying to imagine this on the criminal side, where we have organizations all over the place to, justify situations where there's been predatory prosecution, and just the fact that there's no recourse on this side of the matter is a little astounding.
It really is, and I think we should never lose sight of just how extraordinary this is, how unusual it is, what an outlier power this is. I mean, I couldn't imagine it happening in any Western democracy, quite frankly, and it's just honestly astounding. Chris, you had talked about a couple of cases were on the FOIA front, and I just wanted to develop that point a little bit more as to the two reasons you've been given. I think you had one of them on your phone as to why that they can't give you information out from a government agency, and then the follow-up reason they can't give you information.
Yeah, without pulling out the phone. It's basically, written into the code is they will not disclose any files for a criminal or civil investigation, whether or not that investigation is pending. So one big loophole is if something's under investigation and we ask for information, they don't have to give it because it's under investigation. If the case closes without going to court, they don't have to give it because they don't have to turn over their files.
Right.
In situations where there is a death that happens under curious circumstances, at one point in time, at the very least, what we got is cause of death. Was it accidental? Was it homicide? Or was it natural? They have stopped giving us that information as well. So if you have a suspicious death, even if it's in a public place, and we've had some very strange ones over the years, one in particular that went all the way to the Supreme Court and got the information sealed, which is used as the precedent to make sure that information doesn't get released in any current situations. So yeah, they've just created a perfect loophole where we really can't gather any information inside the criminal world.
And NCLA is running into the same problem in terms of a control deficiency at the SEC, where files of the administrative law judges were accessed by the enforcement people bringing the administrative claim. And that was a big scandal. It was covered by the Wall Street Journal. And as we have two FOIA actions, one in the DC District Court and one in Texas. And 2 years after that scandalous disclosure, we still have nothing. And we could have tried to get the information in discovery, but because in the very case that we were dealing with the FOIA issues, we had won a Supreme Court decision that allowed us, for our client, to go into court and challenge whether any of what you've gone through is even constitutional, okay? And so what did the SEC do? They dismissed all 42 cases so that they could not be challenged on the constitutionality. And what was their excuse? The control deficiency. So, and then that means you can't go and get the information on what happened with that in discovery. So this problem of the ability for the agency to maneuver any kind of public scrutiny of its internal actions and how it treats Americans really is broader than just the gag. And it's the object of a lot of our time and resources here at the New Civil Liberties Alliance. We're bringing this challenge in the Ninth Circuit Court of Appeals for two reasons. One, we think that that circuit has generally better speaking law in terms of not being so deferential to agencies, because that's been our problem so far. We brought a suit in the Second Circuit They just didn't want to hear it under the procedural rules. We brought it in the Fifth Circuit. Again, we were lost for procedural reasons. And courts defer way too much to agency power and agencies' decisions about their power. And so we're trying in the Ninth Circuit because we think the law is a little bit better there. But the Ninth Circuit also has two precedents that are helpful. One is they had a situation where there had been some dispute with a county commissioner, and a condition of settlement in that case was that in the future, the defendant would never speak critically about the county commissioner. And the Ninth Circuit Court of Appeals said, no, unconstitutional condition. And a very similar case had settled again with the government, in where one of the conditions of settlement was that you never run for public office. And again, the Ninth Circuit said, unconstitutional condition of settlement. So that's why we've brought this challenge in the Ninth Circuit Court of Appeals. We hope that because they have that favorable precedent that really is so similar to what you have been exposed to, that we will, hope to be able to prevail on that as well. Let's see. What you've both read the Hester Peirce's dissent. What jumped out at you? Chris has already talked about that, but I'd be interested in what you thought as finally a commissioner who spoke up and said,
Yeah.
maybe this isn't something we can do.
Yeah, I think the part that, well, she got it. I mean, the first thing that came to mind was she gets this. And she sees the ethical issues with it. But the part that really got me was when she mentioned that even if the complaint had wrong facts in it, or whatever you want to call it, misinformation, whatever your terminology is, that you're telling somebody, you're basically forcing them to be unethical by saying, I can't admit or deny what's in the complaint when there's maybe untruths in it, and you're making them basically lie.
Yes.
And I have a really big ethical issue with that, and religious one as well.
Well, and that's both a lie in terms of what the actual facts may have been against you, but there's also a series of lies. We talked about this a little bit earlier, but I do want to emphasize the point that you're also saying you consent to waive any hearing or opportunity to be heard. You consent to be gagged,
Right.
And you consent to any number of that. This is not extortion. You've not been pressured, and none of those things is true. You're forced to say untruthful things and sign a
Yes.
document, and that's non-negotiable.
And actually, to your point, I kept saying to the lawyers, well, if I'm supposed to be submitting this as if I'm proposing this settlement, then why can't we be drafting it so that I can be truthful that I actually did propose it?
I forgot that part.
Right? Like, I just, let them mark it up, but at least it actually really started from us.
I find the whole thing is a pack of lies, because the document Cassandra had to sign is called offer of settlement.
Yeah, I'm
It
like,
is
how
designated
did
to
I
be her
offer
idea
this?
to do all of these things?
Right.
Pernicious, diabolical.
It says that
it's
it's
not
her.
an overstatement.
It says that it's essentially her idea or
Yes.
my idea, and that we're presenting it in hopes of the goodness of the
Right.
commission will review it and will accept our offer, and we're coming hand in hand, and it is their document.
And it's non-negotiable.
And it's non-negotiable, and it is really interesting.
It is
If I can add
non-negotiable.
on just Commissioner Peirce, a number of years ago, we found her, and with the last commissioner, to be one of a few reasonable people on the commission relative to certain issues. And she actually wrote an article called Reasonable Pants. Reasonable Pants. And what it was about is when we first went into this, we're like, okay, so why are we in enforcement? It doesn't even make sense. We're not even part of this. We'll help somebody that's getting enforced. We didn't realize at some point we'd become a target. And it was because we had the deep, or what they perceived were deep pockets, right? So everybody else that kind of left by the wayside, we started becoming the focal point of it because we could pay reportedly a large fine, and it'd be a big capture, right? Which it didn't end up being either of those. But the reasonable pants was, and we continually went through the 4 years that we were there as though they're going to discover 70,000 documents that we provided to them through that and multiple audits. Anytime they bring anything up, we bring our auditors in, say prove against that. And through all that, we thought they will see this and then we'll just move back into regular SEC and not be in any enforcement. There was never a case that was going to be in there. And that's what Commissioner Pierce talks about, is that once you're inside the enforcement, it is a 98% settlement. It's not a 98% settlement of who they choose to go after. It's 98% settlement because there is no getting out of the spider web.
And another important document, and I'll let you speak in a minute, but I just want to mention, she wrote an article called it was a speech, The Why Behind the No. And in there she talks about how people are compelled to settle because they just have to get on with their life. But there's a regulatory problem there as well. When you settle, say you're in a certain type of position, or you and yours is different, and these cases do differ. And I will bring up Chris Novinger's case. He's one of our people who could not be here today, but in his case, the Texas Supreme Court changed the law to say that something that had not been a security is. 3 days later, he gets charged. Okay, so what he had been doing is perfectly legal. They call it a security. Next thing you know, bam, he's hit. And what they then do when he settles that case, everybody else who had been in that business, they say, well, Novinger settled. This is now precedent. And so what the SEC is doing is using these extorted settlements as the equivalent of case law precedent as to why everybody else has to succumb and submit to these settlements, because they have a whole binder full of 20 of these settlements. And that's not law.
It's regulation by enforcement.
Right. Well, and Ray
that.
Lucia, who couldn't be here today as well, he had a case, and I can speak about this part because the SEC, in its dissent, two dissenters, when they were reviewing his administrative law case, they said that the SEC was making up a rule out of whole cloth because the administrative law judge, who was notoriously horrible, so bad that Justice Kagan called him out by name in the Supreme Court.
Wow.
What that administrative law judge said in Ray Lucia's decision is, under the meaning of the term that I have found today, you have violated the securities laws. That sounds like retroactive lawmaking to me by an administrator who has no lawmaking power. And so there are a lot of larger things that get wrapped up in this process. And that's why speaking to Congress about what this permits, what this allows. And again, the rule itself, passed without notice and comment, has no provision for a gag in it. They just think there is one. They say the rule itself just says the commission really doesn't want people going out, settling and going out and saying, well, I didn't really do it. But it doesn't say that they can then gag them. They just inferred that from an illegally passed rule. So, I mean, it truly is a laundry list of procedural and substantive violations of people's First Amendment rights, their rights just to be governed by law that's passed by Congress, not by some administrator, conjuring up a theory of a liability in a back room at the SEC. So the stakes are very high, and the abuses that this permits are startling, shocking, and dismaying. And so I am very pleased that you are willing to fight this. Have you read any more of Commissioner Pierce's?
Well, I follow her, so yes. I just, the last piece I'd say is about getting on with your life is that two things that they put in there that they seemingly have as part of their statement is one, penny stocks. So the majority of people that have a ban for penny stocks had nothing to do with penny
Right.
stocks, but it's just an automatic within there, and that's why you get terminated from the Schwabs or the American Expresses or whomever else in the thing. It's like it had nothing to do with penny stocks. This was a private, transaction.
Oh, is that why? I'm like, what
Yeah, and could not argue that one out. The other one is that not to be banned. I was not to be banned out of the industry by any means. And technically, I wasn't even in the industry, so that was kind of an interesting piece to be on the bad actor list. But now have a 2-year ban with a right to reapply if you're not part of an organization. Otherwise, you have to go through FINRA or whomever else. They have no procedures for allowing you back in, and actually the previous commissioner to Clayton has a undocumented statement saying we don't actually let anybody back in.
And,
So that's part of the agreement.
Ray
that you signed.
Lucia can expand upon that as well. It's, and realize these things are all untruths. You say you have a right to reapply, but they admit publicly that that's futile.
Doesn't mean anything.
right.
And so that's also untruthful. And so what we have here is a collection of government untruths, if I use the polite term, that is embedded into place through this very dark system.
And we can't bring it forward. And that's the unconstitutional part of it, is that we can't speak to the press. We can't speak
Right.
to our
Lawmakers.
Congress, our representatives, and say, look, this is what's going on.
Right.
And one of the things we submitted in our Fifth Circuit Court of Appeals that I thought was very powerful, and we even did the hyperlink so the judges could see it live, was there was a very notorious case several years ago with Rajiv Gupta and Raj Rajanatram. It had to do with Goldman Sachs and all kinds of stuff, and not to get to the merits of the case, but they were charged. They both were found guilty. They both did time in prison. Criminally, yes. And they're both on CNBC and on Squawk Box saying to Andrew Ross Sorkin, they got it wrong. Here's what's wrong with the SEC's case against us. We respect the jury. We were glad we had the opportunity for a jury trial. We think they reached the wrong conclusion, and here is why. And at the end of one of their speeches, he says, I'm very proud to be a first-generation American because no matter what this system put me through, and I'm not saying he was guilty or not, that's not the point here. What he said is, I'm proud to be an American because in this country you can freely speak and tell your story.
And it's very funny because my mother is a first-generation American. And that's another reason why I'm doing this, because the country she came to and her parents came to is not the same anymore. And I know that it is heartbreaking to her that I don't have what she had.
You would bring up a really good point. This is one I hadn't had on the agenda, but I want to develop it because one of the reasons we brought Barry Romerill's case is that in the Second Circuit there was a great precedent. I mentioned earlier we were in the Ninth Circuit because there was pretty good precedent. Second Circuit, there was a great precedent. It was a 1963 decision that said that people, even voluntarily, could not agree to be gagged because it was enforced by a court order, and that prior restraint was a First Amendment violation that was void the day it was entered, and 30 years later it could be voided because the judge had no power to enter it in the first place. What was heartbreaking, truly heartbreaking to me about taking Barry Romerill's case to the Second Circuit is that they distorted that precedent. They actually said the case was about something it was not, and they would not follow the own controlling law of their circuit, and basically made a very bad decision on how to deal with that. And so, it's heartbreaking but it's also really interesting. You say your mother came to this country. In the 1960s, I don't think if anybody knew there was a SEC gag, it would have ever survived. And so what has happened to us then? Have we become sheep? Have we become so used to administrative power taking hold over our lives that we think we can't challenge it, and our courts doing their job in vindicating even their own precedents, which is supposed to control how they decide a case, and they're not. It's very troubling, and
It is.
I think there is a judicial reluctance to admit that for 50 years they've been entering unconstitutional orders.
Well, hopefully we have some brave judges that are willing, like we've been willing to be brave. Hopefully there's some over there that are.
That's
too.
what is at stake, is judicial fortitude.
I think it is, you talked about it in the 60s and Gideon v. Wainwright, which caused public defenders to be mandated essentially across the country, right? And that took almost 3 decades of law and cases coming up and being overturned. That this follows somewhat that, which is you have an overpowerful government, and that's what our Constitution was set up to give the rights to the government, not the other way around. And that this is ripe to be heard now, and the time is right. And I am pleased that you guys are bringing this forward because it's the right, it can't just be one voice. It has to be a collective voice that says, no, it is time that we need to get this right.
And we're so glad we have 12 parties to this lawsuit, and each of them has a different story. And we have Chris here representing the interests of the press, and also Reason Magazine, a very valued co-petitioner here, and they've been writing about the gag problem. And I'm hoping we're going to do some more publicity with them as well. But this has been great. Do any of you have a final thing you want to say? Because we're getting close to time to close, and for questions.
Yeah, no, if there's any questions.
Okay. Okay, well, we can just start with the Q&A then.
So one thing I want to touch on is
This is Kara Rollins. She's my colleague, and she
I'm
has
here
been.
if anything gets forgotten.
She has been at the forefront of this fight.
So, one of the things I think on your last ending thoughts, I think dovetails nicely with the petition right. Where is Congress? Are they asleep at the wheel, or is the gag rule playing an issue with oversight of the SEC because no one can raise the issue?
Chicken and the egg.
Yeah.
I think it's kind of like the Chevron doctrine debate that's going on right now, right? That you look at it and Congress defers some of their thoughts to these agencies. And they do that because they can't possibly know everything about everything, just like judges can't know everything about everything, right? So they put it in there. But they still can't give away their lawmaking ability. And that's what they've done in this case, is they've given the authority to the SEC through examination and enforcement, the ability to create law. And I think that for them to take it back, I think is an interesting piece, and it caused them to be accountable. And it's going to take, I think, the courts to cause Congress to be accountable.
We have an online question. It's interesting. So she wants to know, could you testify in a closed or secret hearing to Congress to let them know what's going on, or would that also violate the gag order?
If
In
we
my
were
opinion,
subpoenaed,
you could.
right?
The
If we
rule
were
itself
subpoenaed.
says if you're under oath.
Right, if we were subpoenaed.
So I think the implication of your question is that Congress could hold hearings and allow people to tell their stories, because the rule itself says that if you're under oath, you are relieved of the provisions of the gag. And they had to put that in there because they knew that they were suppressing speech. And it's just the fact that they are willing to lift it in that situation means that in an acknowledgement that it has to be lifted. I will also note there's another condition on that lift. It is lifted for you if you are under oath in a proceeding, so you can tell the truth, unless the SEC is a party. Then you can't.
And I have that going on as well.
Yes.
Yeah.
So, I mean, Honestly, diabolical is just the word that keeps coming to mind in terms of how this is constructed as your idea, your offer.
I would say, though, to the statement about Congress is, yes, when you got opportunity to be called under oath, but when your story can't be told to them until you're under oath, they're never going to find out the facts to actually hold a hearing. There's no point. Right? So it's like it doesn't exist. And so in most people's cases, it doesn't exist.
That's true.
Yeah, I mean, we've got, Congressman Jim Jordan doing investigations into, like, government,
Weaponization.
yeah, weaponization, thank you, which, I think this would kind of qualify on some level for, that. And yet, we can't even bring it up as a topic to get there.
Well, that's one reason why we have so many petitioners in this case. We were doing it, person by person with Barry and with Chris Novinger. And, I think it's very easy for a court to say, you signed it, too bad, go away. I think it's going to be harder for in this court where we don't have the same procedural hurdles we had in the earlier litigations to say, okay, all 13 of you, and including you, wise guy who wants to talk to people, go away. That's going to be harder, I think.
My question is for both Cassandra and for Thomas. Cassandra, you mentioned that you were glad that you didn't listen to your attorneys and talk to the media at least a little bit. I just want to point out that was before you had NCLA representing you. These were your attorneys with the SEC.
Oh, absolutely.
Defending against the SEC. But my question to you and to Thomas is, what would you tell people who are at that stage of an investigation or enforcement proceeding? Should they talk before a gag gets put on them? What would you recommend that they do? Is there any advice that you give when people call you that you'd like to share
Yeah,
today?
I mean, well, I'm not an attorney, so I can't give legal advice. But I think for me, the advice I give people is pray and do what is right, regardless. You have to be authentic, and you have your own moral values, and you have to do what's right, and have no fear, because ultimately none of this is in our control. And that's the one thing that got me through all of this, is I had no fear, because I knew there was some reason why I was put in this precarious situation, and that God was gonna be there to show me the path. And so, that's the advice that I give people.
It's an interesting question. The first piece that I would give as the advice is relative to get your affairs in order.
That sounds ominous.
Right, you have 6 months to live. But yeah, he's right, there is that.
And if you are willing to get out the checkbook, don't settle. And understand that your best point is to get in front of a judge if you possibly can. But if you are going to settle, you will lose all of your rights, essentially. And just understand that. So, if you want to write a memoir, do it before it happens.
I thought about that too.
But that is the piece.
I want to give a shout out too in response to this. One of the wonderful things that has happened in the fight here is we've had many, many beautifully written amicus briefs by the highest level of the legal profession. We had one one at the Second Circuit that said, "There's no securities sedition law." It was wonderful, but a particular group comes to mind, and this is Mark Cuban, Nelson Obis, and Philip Goldstein, who have consistently supported this, because they actually had the resources and the determination to take it all the way through and be exonerated. But they know what that cost. In the case of Nelson Obis, it was $12 million in 12 years. Mark Cuban's case fell apart once he got it before a jury. So they've been very supportive in terms of NCLA's work to preserve jury trial rights. And I think that shout out to those supporters here is very appropriate.
Another online question says, I understand there is a clause that says not only can't you talk, but you can't allow an impression to be created. So what does that mean for you folks and for the press? What can you report on? And if he reports something, do you have to file a counter editorial or op-ed saying no, that's a misimpression? How does that work? I guess our online viewer wants to know.
You have to really be very careful about what you say. And Chris will, when I settled, they called me. And I said, I can't say anything.
Is that our
Basically.
reporter that's asking that question? Who's watching this today?
It might be, yeah. There's been somebody that knows a lot about the case commenting on it.
Well, I want to explain. That's in the terms of the gag order. They say you can't create the impression, even the impression that there might have been something wrong with the agency's case against you, or let somebody else do that.
Right.
Now, that is just nuts. I mean, there's no way that they have power to regulate the speech of somebody else who
Right.
wants to talk about your
Right.
case. And there's also no way that the idea that they can regulate the impressions you can create is just so contrary to any concept of why law has to be direct, not vague, and that you need to know how you are regulated if they're going to put a rule in place. So we have always been making the vagueness due process challenge in these suits, and that's something I failed to mention.
Greetings. Nice. Thank you guys for fighting the good fight. I'll start with that. And then just quick question. Peggy, I mean, you labeled this pernicious, outrageous, un-American. I agree across the board, but I missed, I think, why does the agent, what is their reason for doing this? What do they point to justify this?
I'm going to quote Floyd Abrams' cert petition on this. He gives the stated reason. It is the commission's position that people should not be able to settle and create even the impression that they might, the agency might have been wrong in their case against him. And Floyd Abrams said, in other words, the agency doesn't like to be criticized. And that's it. That's the sole policy reason they're able to summon up. And yet the First Amendment's core purpose is to allow Americans to criticize their government.
Yeah.
I don't even know if I can say this, but let's just say this. My theory is, I find it fascinating that once a year, the head of the commission goes before Congress to disclose their fiscal contributions into the U.S. Treasury every year. And every year, that number gets bigger and bigger. Okay?
Well, I think we're in Justice Gorsuch's footnote here about the ability to outlast and outspend.
Hi. Not to go into the weeds too much, but I'm fascinated by this, and I am not a lawyer. So, but I tell people say about me is I litigate in the court of public opinion. So here's my question. So under oath, your gag order is lifted. So technically, you have a congressional hearing, deposition, wherever it is, it's under oath. Can't that be cited in a story with quotations because you're referencing it with a footnote? Does that get you around to let you tell your story in an opinion piece? Or a friendly person? I mean, all you gotta do is take your quotes. It's just like you know that which point you want.
I told Peggy a quick story about a very unusual death in Delaware. It was a 7-year-old. It was believed to be suicide. But they would not release any information. And we tried and we tried and we tried. Whether the boy was in state custody or not, was placed by the state or not, we did not know. Very accidentally came out due to some unique questions by a state senator in a public hearing. And they answered those questions, all the questions we'd asked them. they answered. And when we asked them after the fact, they said, well, a public official asked it in a public hearing. So we told the truth.
Might be time to have a public hearing.
Public document is citable.
Yes.
I just wanted to ask about publicly traded corporations. When they settle, they have an obligation and a legal duty that the SEC itself enforces to be frank with their shareholders as to why they settled these charges and why they're paying shareholder money in penalties or whatever other sanctions. What can they do? Can they navigate this if they don't believe the charges were warranted, but they settled it essentially because it was cheaper than litigating or other business reasons? They can't explain that, I guess?
Well, it's
No.
absolutely contrary to the SEC's own full disclosure
Right.
policy, and you're absolutely right about that. But you would have to find a corporation who cared. Who wasn't just
Right,
who wasn't
'cause-
just buying
yeah.
a piece, but who cared. But your point is very forceful and right.
Yeah.
This is why the American people should also understand is that the people that really get harmed by the SEC are not the Wells Fargos and the Schwabs or even the Mormon Church when they get a large fine, right? Because especially the publicly traded corporations, they've set aside that, and then it is the shareholders who pay for it, and generally the stock bumps after it's settled. Right? When it is an individual business owner, even if it's with an AUM of several $1 billion underneath, you don't get a bump in your stock when you pay for that, and it is your own personal reputation that they attack, and it's a different playing field, and so the disclosures become much more punitive, I think, to the smaller business people. And that's why, again, this crosses not to just the mega corporations. I think there's a whole set that says, oh, it's the SEC and you're in finance and, big bad group of people anyway. It's not. When you look at the list of all the people that are brought against it and can't afford it, it's small individual business people.
And to follow up on your point, there have been a few occasions where banks, and I can't remember whether it was Citibank or who did settle, and they kind of came out and said, well, this wasn't that big a deal. And the SEC said, you better retract that statement or we're going to recharge you. So
The CEO.
Yeah, and one of the things that is frustrating for us is in its briefing, the SEC will often say, well, we're not likely to enforce this, but they do, and that's so important.
Oh, they call.
So I think we are through. We have, this has just been wonderful, and I love the way the conversation flowed. I learned so much from all three of you. And so on behalf of the New Civil Liberties Alliance and our panel, who are brave citizens and members of the press, willing to vindicate the First Amendment, I want to thank you all for joining us. Stay tuned for our next Lunch and Law panel. See you then.
Thanks.